Can I ask you about Justice Kagan's questions about how many legislators would have to be present? I just want to be sure I understand where in Rule 24 you're grounding this language. So I take your point that you have a different interest than the Board of Elections because they're interested in executing the election, you're interested in defending the constitutionality of the law, there's a tug. Would it be fair to say that your position is that when the interests are different, as they're here, maybe the Turbovich case casts some light on this question, that it would be rare to find that the existing party is an adequate representative because someone with different and interests that are in tension can never adequately represent the intervener's interest?
Well, the test is under Turbovich, are those interests such that they may not always dictate precisely the same approach to litigation? In other words, Turbovich teaches that it's a minimal burden, and here we've amply satisfied.
I understand that, but I guess what I'm saying is if I'm granting you, I'm saying assuming that you're right, that these interests are not perfectly aligned between the Board of Elections and you, that it would be very rare to find that your interests could be adequately represented. It's not even really much of a question, because when the interests are different, the question of adequate representation is just, how could you represent that interest in the rule of 24A if the interest is a little bit different, potentially in tension with?
Yes, Your Honor, that's exactly right. That's the teaching of Turbovich, because nobody was suggesting in Turbovich that the Secretary of Labor was not doing a good job, or that he had his interest wasn't at least partly aligned. He was the petitioner's lawyer, and he had the exclusive responsibility, the Secretary of Labor did, for challenging the election.
Okay, so then let me take you to Justice Kagan's question about the succession of legislators that might come in and try to intervene, and maybe state law might even give them that right. Then would your position be that, well, all of those interests are the same, all of those interests are aligned, but when you have would-be interveners who have interests perfectly aligned, they all have the interest that you have here, say, in defending the constitutionality of the law, that then there is adequate representation?
If the interests are entirely aligned, we can't invoke Turbovich as a basis to intervene.
Right.
We could point to the fact that, in fact, the representation has not been adequate, and we can point to the fact that we have a different perspective. We're a separate, co-equal branch of the government. So,
but in Justice Kagan's hypothetical, it was all legislators, say all from the same branch of the government.
Yes.
And I'm just trying to ground your answer to Justice Kagan when you said, well, number 1 can get in and numbers 2 through 10 cannot.
Yes.
I'm asking you, would that be because adequate representation would be satisfied, assuming that there weren't these other factors like they're doing a bad job? Or
yes, Your Honor. That's right. So the first step under the analysis under Donaldson is to identify the interest. Then the second step is to identify whether the entity has been assigned as an agent of the state. And then the third step is if there are different interests, but only if they're different interests do you get to the Turbovich type of analysis. If the interests are identical, then there's an adequacy of representation on that metric.
But are we to defer